try and leave some good time for Q&A at the end. It's going to be a lot of information. So thanks all of you for taking your time. Look forward to having a great conversation. And Eric, we'll start with you. Thank you.
To talk. Okay, great. First of all, thank you for having me out here. It's truly an honor for me as a former student athlete and now an insurance professional working with over 50 universities nationwide. It's truly an honor to be here, so thank you for having me. I got into this industry after an 8-year professional career. I understood insurance as a consumer. When I played at University of Kansas, I had a policy my last 2 years in school, so I understood insurance, like I said, as a consumer, as a former student athlete. And so when I retired from playing in 2008, got into coaching for 3 years, and I was tired of begging coaches like Coach Bray for a job, so I decided to shift gears and stay in Southern California and get into the insurance industry. My business model is very simple. I only call coaches and compliance directors. I do not call families directly. I do not call student athletes directly. I find it intrusive, and I also find it where I can, some schools can be caught off guard. So, like I said, my daily, tasks include, researching drafts for all 4 major sports, and then following up with compliance officers to discuss potential options available for the student athletes. From there, if they decide to use my services, great. If not, then we can all go our separate ways. Obviously, I played for Roy Williams at the University of Kansas, who runs a very tight ship. So I understood the rules from the NCAA as a student athlete. I understood the letter of the law and the spirit of the law for those rules. And so it was something that I applied to my career moving forward. A small story I talk about is when my dad knew that Paul Pierce and Rayful Prince had a disability insurance policy, so he said, hey, Eric, you should probably go talk to Coach about getting a policy as well, too. And he said, hey, Eric, go talk to Richard Consum down the hallway in compliance, and he'll take it from there. So I understood that business model, and as I was walking down the hallway, every student athlete's or professional athlete's biggest fear is, what am I going to do when I'm done playing? And so there was a seed planted in my head when I was walking down the hallway that, okay, if I don't make enough money to retire, after playing basketball, that I could always sell insurance, and so and work with student athletes doing this. And so that seed was planted, and then it came to fruition later on in life. Let me see what else I got here. So when I was in school, I took out a loan to pay for the premiums for my insurance. It was something you had to do back then. Either your family could, if they could afford it, you'd pay for it that way, or take out a loan. My family was not in a position to pay for the premium, so I did take out a loan and then eventually pay the loan off. I thought it was a good thing for me. It taught me financial accountability. It taught me how lending works, and so it was a good experience for me in that. Now, obviously, I've been in this industry for 7 years, and about 5 or 6 years ago is when the NCAA full autonomy rules changed, and so as a producer, I was having to get student athletes loans. It changed overnight where the schools could then pay for the premiums out of the SAF, which completely changed the market for me and increased the business, tenfold, whereas universities were then using the SAF to pay for the premium. So it was a very, I'm trying to think of a word, but it changed everything overnight for me in a good way. Simple products that are available for student athletes. The first product is called Permanent Total Disability. It's the cornerstone of our market. It's what you buy first. Basically, in layman's terms, it means you have a career-ending injury. You cannot play basketball, football, baseball, or hockey ever again. Examples of that would be being diagnosed with cancer, shattering a leg, something of the sort where you can't play your sport ever again. With that, a lot of athletes would dismiss PTD, saying my career's never going to end, with the advancements of medicine and what have you. So what Lloyd's of London did is developed a product called loss of value, which basically they take a projection of where you're going to go in the draft. They set a monetary value on that. They take off about 50% of that projected value, and they assign what's called a threshold. So if you're projected to be a lottery pick in the NBA, they would set your threshold at, say, 15. If you have an injury which is not career-ending, but it's proven to make you fall past your threshold, they will then indemnify you up the difference of where your threshold was and where you signed. With that, there's been some gray areas with what's caused the fall and what hasn't caused the fall. So there's now been a new product called critical injury that's been introduced to the market. about the past year, which is a defined benefit plan where there's a category 1 of a certain injuries and there's a category 2 of injuries. So category 1 would be a torn Achilles, torn ACL, rotator cuff, Tommy John, and then for the category 2 would be, you know, a torn quad or hamstring, pectoral muscle, triceps muscle, and you would get a defined benefit for the specific injury. So it takes out the gray area. A lot of schools like it. It's expensive, but you know what's exactly going to happen when you have a certain defined injury. Finally, for me, and I've kind of touched on these already, and I'll wrap it up. I hope I haven't gone over 8 minutes. Okay, good. I pride myself on 3 pillars of skill. So I know basketball very, very well. I played at Kansas. I played professionally for 8 years. I played for Hall of Fame coaches. I have relationships with front office personnel, GMs, presidents, what have you. So I understand basketball and the NBA draft, you know, on the full gamut. So that's one pillar of my skills. Second is I know insurance. I know how policies are underwritten. I know policy language. I've been to London to meet with my underwriters at Lloyd's of London. I've hosted them at my office in California. I have a true relationship with the underwriters, so I understand insurance as well too. And finally, and most important for this panel, I would say I have an understanding for, like I said earlier, the letter of the law and the spirit of the law for NCAA guidelines. And so the combination of those 3 really allowed me to, you know, work with the universities I do, being fully transparent, being an educator, and then an order taker after that. And so very simple business model, like I said, calling coaches, compliance directors, what have you, and then going from there. So that'll wrap it up for me. I'm sure you guys have some questions afterwards, which I'll definitely welcome. And go ahead, Tom, from here.
President Cartwright and Chairman Duncan, it's an honor to be here. This marks 30 years since I've been involved in the Knight Commission, serving in 1989 as a founding member with Father Ted and Bill Friday. So it's been a big part of my life, and so I'm happy to be here. When Amy called me and asked me to talk about some issues, we talked about the name, image, and likeness issue and how recent legislative efforts, I think, have catalyzed a discussion on these matters. And so our members are beginning to engage in discussions on this. We have a meeting in June. We'll have another one in September. But our June meeting is going to really focus on it and really try to coalesce where our ADs stand on these issues. I can tell you just anecdotally that we've had a lot of comments from ADs. Some think it's a very good thing, giving Olympic rights to our student athletes. Others are concerned about recruiting abuses. Others are concerned about Title IX if it's administered at the campus level, and others are worried about the slippery slope argument that this could lead to, you know, full-scale employment classification for these student athletes. So, but the big point here is that it's really because of, I think, a lot of these state and federal initiatives that have compelled this discussion. And I kind of want to give some perspective on that, because a lot of people say, well, you know, government's intervention's a bad thing, it's the boogeyman and everything. But in my experience, I can tell you, if you look down the history of college sports from Teddy Roosevelt himself really being the force that started the NCAA, to Title IX, to when I was in Congress, we passed some disclosure bills, the Student Right to Know Act, which was a bill that I sponsored, and Bill Bradley, to disclose graduation rates of students and student athletes, which at the time in 1991 was very much opposed by the NCAA and the higher ed community. But can you imagine today college sports without graduation rates? I mean, it'd be hard to think about. There were other Equity and Athletics Disclosure Acts, which was about programmatic disclosures about your programs. The whole Knight Commission database is based off that legislative initiative, and sports agent legislation. So there's been a history of legislative initiatives that have been really positive. So I don't think you should rebel against the government taking a look at these things. And if you look at it, there's probably 3 big categories they're focusing on. One is compensation, primarily name, image, and likeness. And that involves a Washington statute, a Colorado statute that's going to be filed, and Congressman Walker's bill at the federal level. And those statutes basically provide that student athletes will have name, image, and likeness rights. Congressman Walker's bill is co-sponsored with Ced Richmond, who was a former head of the Congressional Black Caucus. So it's a very interesting combination of a free market conservative Republican Mark Walker going along with Ced Richmond on legislation which is basically looking out to protect student athletes. A very interesting marriage, but no hearings scheduled yet, no other co-sponsors. And so I think that bill is more symbolic at this point than anything else. The real bill in this area, I think, that has some teeth is in California, where there's legislation introduced to provide name, image, and likeness rights to student athletes. That has passed committee. That is anticipated to go to the Senate floor any day. Probably will pass the Senate floor, and then it will go to the House or the Assembly in California, where, like many issues, oftentimes California is the bellwether. And that would create a tremendous problem for the NCAA, because here you'd have a state basically permitting name, image, and likeness for the 24 institutions in California, and while across the country it would be illegal. So that's one bucket of compensation for student athletes' name, image, and likeness. The second bucket is student athlete welfare protection. And in that area, you have bills in California to increase legal protection for student athletes. Congressman Al Lawson, a former basketball player, played in the NBA a little bit, has put a bill in to overturn one and done, so that wouldn't be permitted anymore, and to provide student athlete benefits like summer jobs and insurance guarantees and those kinds of things. Again, those bills haven't really gotten much support, but those are the levels of bills at the student athlete protection area. The last area, which I think is very interesting, is limiting severance payments for college coaches and other officials in college sports. 2 states in the country, Florida and Illinois, passed laws that limit severance to all public employees to 5 months. And those bills are in effect today. The only difference in Florida and Illinois is that it does not include related foundations and related affiliate groups. I am told, and I've seen a draft of a bill, that there's going to be a bill drafted at the federal level and submitted that will limit college coaches' severance to 12 months going forward on new contracts. That would be a prospective limit on new contracts. And they're doing it by tying it to Title IV money. In other words, if you take a Pell Grant, if you take a federal grant, which is $100 billion in the federal system, then going forward, you cannot give a severance payment out for more than 1 year. That bill is being circulated in draft to various associations and so forth, but I think the crux of that bill is that it's tying Title IV money to college sports reforms. And I think that's very significant, and I think it could have some teeth down the road. Finally, let me just say, as you know, Chris Murphy has, I just want to say one thing. In the last 3 years, $208 million of severance payments have been obligated in really college sports for about 50 coaches. And so some of that may be offset, but there is a reaction at the state and federal level against these kind of excessive severance payments. The last point I'm going to make is that Chris Murphy, as you know, the senator from Connecticut, has released a 15-page kind of manifesto about, why doing something more for student athletes is a civil rights issue, although there is no legislative attachment or direction to that. The point here is politics is too serious a business to leave to the politicians. As President Howard said, I agree with him, it's important for the college sports community to get ahead of these issues, educate legislators, and continue to help them understand the nuances involved in these various issues. Anyway, thank you very much.
Good afternoon, and thank you for the opportunity to provide some remarks and to answer some questions. Regarding the topic of name, image, and likeness, as the NCAA governing body has been addressing it. So earlier in the first panel, there was the reference to the creation of a working group that is association-wide to address and to study the question of whether name, image, and likeness compensation can fit within the present collegiate athletic structure. And I think it is out of necessity, indeed, because of the legislative proposals that Tom mentioned, not only the federal but also the state initiatives. And I also think it's important to note that the rationale for those is to address the needs of all student athletes and not to a select group of student athletes. In other words, it is not intended to be a substitution for pay for play, at least as stated in the rationale. And yet there are many out there who have used that code, right? Name, image, and likeness must equal some form of payment for athletics participation. And I think it's very important to note that that's not what those bills purport to do. Neither was that what the Rice Commission suggested in their recommendations when referencing name, image, and likeness. They acknowledged it as a thorny issue, but not one to be the substitution for a pay-for-play model. And I would note that even the district court opinion most recently issued in Oakland involving the antitrust financial aid case acknowledged that there is a need and, in fact, a distinction between the pay-for-play model and what college athletics is. So none of the necessitated reasons for the working group are to address the pay-for-play issue. It really is to look at, and if you look at the charge of the working group, to see how within the structure of today's world, today's environment, is it the fact that our rules right now make the student athlete look less like the regular student, given all of the student opportunities that exist in social media, in influencing, and in the like, and to keep that as the bellwether for the student athlete and the student being given like opportunities, as opposed to moving NIL to a world where the student athlete looks more like the professional athlete, which in other words would be the substitution as a pay-for-play model. So we are looking at the working group charge and how they will go about implementing that. It is, I think, a good opportunity, and under the fact that we have federal legislation pending, the opportunity to have a candid membership conversation. So with that said, I do note that we are talking about applying it within the principles and values that have been the core of college athleticism and indeed amateurism generally. Sometimes those skeptics forget that there are amateur athletics that transcend college athletics. There are other amateur models that do survive and exist. And what happens here with respect to name, image, and likeness also has an impact in those other spaces. And we need to be mindful of that even as these bills are proposed. What is their intent there? And why is there a distinction? So it is to note that the principles and values haven't changed, but today's world and frankly the expectations of today's student have changed. And it is within the principles and values that this working group will look at the expectations of today's student and today's student athlete with respect to their presence and their ability to take their name, image, and likeness and use it in ways that a decade ago weren't even possible, and the innovativeness that can exist within the promotion of their own inventions, their own businesses, their own initiatives. So the things that the working group will consider and where they haven't even met. So to some extent, I'm forecasting something that I believe is the type of categories they will look at, but certainly invite your feedback today and otherwise to other topics that they might want to look at. And all of that will be done within a very quick time frame of a touch point in August and a touch point in October to the Board of Governors. First and foremost, it is the recognition that name, image, and likeness, or right of publicity, is a very, very complicated area of law, and one that is fragmented across the 50 states. There is no federal law, and the interesting nexus between a federal piece of legislation that purports to regulate right of publicity is interesting, given the 50 states and their jurisdiction. Right of publicity and name, image, and likeness is very complicated in the digital and social media space as to when compensation is allowed or not allowed. And I'll point to a very recent case involving fantasy sports and sports wagering, where the question the Indiana Supreme Court addressed was whether the names of student athletes trigger right of publicity such that those entities couldn't use those names in connection with their business. And the Supreme Court noted, the Indiana Supreme Court noted, the First Amendment has a very important place in where right of publicity and compensation come in. I'll also point you to the Marshall case from a few years ago, which recognized that broadcast and photos and things subject to copyright and other intellectual property don't apply to right of publicity and name, image, and likeness to warrant compensation there. So those are things that I think the general public sometimes misunderstand, and things that the working group will certainly have to consider. The enforceability of what model might come forward also has to be examined, given the notion of market value. What is the fair worth of a student athlete's name, image, and likeness, and how is that determined? And I know you'll hear some ideas about that on the panel today. What are the Title IX implications? And that, in some measure, is triggered by whether the school will administer name, image, and likeness in that form of a model, or whether the third-party compensation model is one that is better suited to the idea of a student athlete maximizing their name, image, and likeness potential. But there are certainly implications there. Within all of this is the legal risk, right? So none of this and what we're doing with the working group is to suggest that the appeal we're putting forward in the Alston case should not go forward. To the contrary, we think that court got the antitrust analysis wrong, but also their micromanagement of college athletics and a governance and the ability of the NCAA to govern makes these types of conversations very, very challenging, right? If there is going to be a new piece of legislation that is trying to address the abuses of name, image, and likeness, only to be brought by litigation by those that would continue to advocate for the complete pay-for-play model. So we have to find whatever protections we can given the pending legislation. There is the complexity to the student athlete, right? Within the right of publicity is fundamentally driven from the right of privacy. And so the idea that the pressures mounted on student athletes to maximize the value of their NIL and the pressures that are felt there in today's social media and digital marketplace is also a challenge. Certainly the working group will be concerned about recruiting abuses and the idea that you don't choose the school, not even for the coach and not even for the campus, but because they offer the best sponsorship package in the form of third-party boosters or perhaps directly from the institution themselves. So I think there are certainly some interesting models put forward out there. I know Tom made a reference to the Olympic model, and there are often some commentaries about that. But keep in mind that Olympic athletes are using their NIL money to augment their training, housing, coaching, and world-class performance opportunities that the college student does not have to engage in. Likewise, note that the Olympic model has significant restrictions on what their athletes may do and when they may do it with respect to sponsorship and the like. So within that, though, I think there are opportunities to look at the ways student athletes can be influencers and can maximize their innovativeness and their creativity as we have seen already being the case. So one of the things the working group really can do is simplify the rules, as the Rice Commission suggested, to make them more understandable for what is and what is not permissible. The rules are complicated, and that was something that even the district court got wrong in suggesting that there were some things that were not permissible that in fact are permissible and are permissible without caps. So we need to do a better job and the working group I think can look at the do's and don'ts of NIL in a way that note that non-athletics name, image, and likeness is actually quite permissible, but highly subject to the interpretation of our campus compliance staff. So what you read in the newspaper many times about this student athlete not being able to write a book and maximize the royalties or not being involved in their own invention is curable, if not the rule, but through waiver processes. But it gets very complicated and very subject to what a campus is willing to do and the resources that those campuses have. So I think there are opportunities that this working group can address to simplify those rules and then look at the athletics nexus to name, image, and likeness and how to try to do that in a way that doesn't create abuses. So I'll pause there. I think I'm happy to entertain any questions, understanding that, and to take any feedback back to the working group, understanding that they have yet to meet, and so this is a blank slate ahead. So I'll turn it over to Gabe.
Thank you, and thank you to the Knight Commission for inviting me to participate and for inviting me back to talk about name, image, and likeness. I'm the director of the sports law program at Tulane. I'm also the associate provost for NCAA compliance at Tulane, but I want to make clear that my views are my own and do not reflect Tulane's views. Hopefully, maybe someday they will, but right now these are my views. So I want to focus on some of the issues Scott raised and Tom raised and NIL issues in general. And I want to frame my remarks around two questions. And the first question is, should college athletes be allowed to be compensated for the use of their name, image, and likeness? And then if so, how? And let me start with the first question. And the should, I think the answer is a yes, but it's a qualified yes. And let me tell you why it's a yes and then why I think it's a qualified yes. I think it's a yes because college athletes, like all other people in this country, have a right of publicity. That is a property right. And many college athletes have created tremendous value in their right of publicity. And at the time when their value is highest, or maybe when the only time it has value, is the only time they're not allowed to capitalize on it. So I think as a general fairness matter, there's an argument that student athletes, again, like other students and other people in this country, should be allowed to capitalize on their name, image, and likeness. But it's a qualified yes, because as Scott mentioned, the NCAA is unique, and college sports are unique. And the courts for decades have recognized the uniqueness of college sports. And they are unique for many ways, but certainly one of them is because of their amateurism model. And the amateurism model has obviously been recognized by not only the Supreme Court, but also by the 3rd, 5th, 6th, 7th, 9th, 10th circuits, and many other district courts, many other federal courts in this country, including most recently Judge Wilkin in the Northern District of California in the grant aid cap litigation case. And those cases in the Supreme Court recognize that the NCAA has a legitimate interest in maintaining and promoting amateurism. And that amateurism is, in many ways, what separates college sports from pro sports. And that consumers demand this college model, this amateurism model. So I think any discussion of name, image, and likeness and whether compensation for name, image, and likeness should be permitted has to be considered in the context of amateurism. And so I think the question as posed is really exactly as Scott said, is how can it fit within the amateurism model? And I think many have argued and continue to argue that amateurism is not a legitimate defense and that all those courts have gotten it wrong. I'm not here to make that argument. I'm here to accept that argument and say, well, how can we come up with a name, image, and likeness system that fits within amateurism? Right? Because that's why it's a qualified yes, and that's why the model that I'll talk about in a couple of minutes, again, is conditioned on meeting the broad restraints of amateurism. But my argument is that allowing some compensation for name, image, and likeness is not only not inconsistent with amateurism. I apologize for the triple negative, but not only is it not inconsistent with amateurism, I think it can actually strengthen amateurism. I think it can strengthen the collegiate model. I think it can relieve some of the pressure on the collegiate model, whether it's from state or federal legislators, whether it's from plaintiffs, whether it's from the public, right, or any combination of them. And I think one piece that hasn't been mentioned yet that I just want to touch on briefly is, I think there's no question that there is an erosion of the tolerance for some aspects of the compensation model in college athletics. And I think that erosion is accelerating. And I think another factor that's going to further that acceleration is the legalization of sports gambling. And I think we see now in the wake of PASPA, there are now 11 states that have legalized sports gambling. We expect that number to increase. And putting aside the NIL issue with the use of athlete names and statistics in sports gambling games, I think another issue that we have to keep in mind is that now there will be hundreds of millions of dollars legally wagered on the performance of college athletes. And I can only think that's going to, again, accelerate the intolerance we have to the current model. So the question is, can we modify the NIL system? And I think we can, and here's the modification that I would have. And here's the modification to the amateurism rules that I would suggest. And that would allow student athletes to receive compensation for name, image, and likeness as long as it is not related to their participation in the game. And let me specify what I mean there. As long as it is not as part of the broadcast or rebroadcast or some derivative use of the game. That was really the crux of the O'Bannon case, that student athletes wanted a piece of broadcast revenue because broadcasts were using their name, image, and likeness. I think there should be a carve-out for those uses. I think those are what I would call game-related uses. I don't think those should be permitted. And the reason I don't think those should be permitted is because I think it's too difficult to draw a line between those uses and pay-for-play. And to be consistent with the amateurism arguments that the Supreme Court and multiple federal courts have accepted is we have to create that line of demarcation between pro and college. Paying salaries to college athletes, as Judge Wilkin just noted, would destroy that line. Even if it's only a penny, that would just make them poorly paid professionals. But once you cross that line, there is no going back. So I would carve out those game-related uses, but I would suggest that it makes sense to allow compensation for name, image, and likeness and other uses. So for endorsements, for autographs, for social advertising, as we'll hear more about. Really anything that doesn't fall into the broadcast or rebroadcast of the game. And I don't think, if properly monitored, properly regulated to deal with a lot of the issues that Scott raised, I don't think that interferes with the amateurism model. Again, I think it strengthens it because I think it makes a brighter line between pro and amateur. If the distinction is that people are paid for their services when they are professionals, they're also not students, but when they are college athletes, they are students and they are not paid for their services, I think you can lay in they are also compensated for the use of their likeness in an endorsement deal. I don't think that impacts whether they are paid to play or not. I don't think that damages, as long as it's regulated, I don't think that damages their amateur status. I also don't think it has to interfere with education and the NCAA's important role in promoting education and protecting education. I think they can go hand in hand. I don't think they're mutually exclusive. I think it can actually be used to enhance educational opportunities. I think it can be used to fund educational opportunities. I think there can be an educational component to these NIL deals. You can think about reflective papers or internships or anything that would not only can not make it inconsistent, to use my triple negative again, but also support educational ideals. And then lastly, just in terms of the part of the NCAA's goals and what the court has recognized the NCAA's role is, I don't think it has to lead to exploitation of student athletes. It could if done poorly, unquestionably, but I think there's also a pretty strong argument that the current rules are what are leading to exploitation of student athletes and creating a black market. And by loosening those restrictions, you might actually eliminate or at least minimize some of the incentive and temptation for student athletes to accept compensation under the table. So, question that comes up is, well, why do it now? We've got the legislative pressure, but why do it when the courts have continued to uphold these restrictions and the broad amateurism model? Part of the answer why I think it makes sense to do it now is not only do I think it's fair, but I actually think it ultimately will strengthen the NCAA's case in future antitrust litigation, future labor law litigation, in future tax cases. Because I think it brightens the line between amateur and pro, and also if you think about the question that is asked in antitrust cases, the operative question, at least that's asked in the NCAA antitrust cases, is whether the NCAA's rules are reasonably necessary to achieve their pro-competitive goals. Here, their pro-competitive goal, among other things, is amateurism. Put slightly differently, are there less restrictive alternatives to achieving amateurism? When you have a blanket restriction on compensation related to NIL, I think you invite challenges because it is very easy to prove that there is a less restrictive alternative to a blanket prohibition. Anything other than another blanket prohibition would be less restrictive. So by maintaining this blanket prohibition, I think you put a target on the NCAA's back. And you put the entire amateurism model at risk. By loosening the restrictions, by arguing the restrictions we have remaining, these are truly necessary to maintain amateurism. I think you make it more difficult for plaintiffs to bring their case or to win their case. By emphasizing the line between pro and college, emphasizing education, I think you strengthen the argument that student athletes are not employees. I think you strengthen the arguments under tax law, again, under employment law, under labor law. And then the question is, well, why make the change now? Why even have a working group now when you have the Alston case, the grant and aid case still pending, when you have the Jenkins case potentially pending in New Jersey? Well, I think these changes, again, would actually be consistent with Judge Wilkins' ruling, with the Ninth Circuit's ruling. I think because this is not pay for play, because this does help create that clear line of demarcation, and also because the NCAA has clearly been given latitude, starting with the Supreme Court and then really every court that has looked at this, to create rules that maintain amateurism. And there's also a recognition that amateurism is not a fixed state. Amateurism today is very different than amateurism 60, 70 years ago, and things that were prohibited yesterday become a natural part of the new definition of amateurism, whether that's athletic scholarships, whether that's grant and aid up to full cost of attendance, or other benefits. We now accept those as part of amateurism. So in fairness of time here, interest of time, the model that I've proposed would allow both individual deals between student athletes and third parties and group licensing agreements. But there would be strict regulations to make sure that these were good faith third-party transactions that were within some fair market value. I don't think that's an easy determination to make, but I think it will help curb some of the abuses. I think some of the fears that this will be abused and will just turn into pay for play and will allow boosters in a local city to just pay a student athlete or recruit that student athlete, those are real concerns. I don't minimize those concerns, but I will note that those were the same concerns that were mentioned when the NCAA considered and ultimately did change the rules to allow student athletes to have employment in season. Right? That was a very difficult fight. They said, well, now a booster is just going to hire a student athlete, pay them $1 million to make photocopies. And now that's just part of, not paying them $1 million, but allowing them to have employment is just part of the NCAA, right? And there are forms that you have to fill out. We can do the same thing for name, image, and likeness deals. Make it transparent. Right? Everything has to be filed with an institution. Put a committee together to make sure that the time demands are realistic. This fits within the education model. Can this be abused? Certainly it can be abused, but I don't think the potential for abuse is a sufficient reason to not allow this at all. What I think we should do is allow it, but then regulate it to make sure that it is not abused. So, thank you, and I'm happy to take comments later.
Good afternoon, everyone. Amadou Kilkenny Diaw. And first, I want to thank the Knight Commission for having me here this afternoon to speak on what is a very, very timely topic, primarily the non-game use of student athletes' names, images, and likenesses. Just a bit of background about myself. I went to Georgetown University undergrad, played on their men's basketball team, advancing to the Sweet 16 in my senior season. The year after I graduated, they went to the Final Four. I still get a hard time about that from a lot of my teammates. I was not holding them back, I promise. But since college, I went straight to UVA for law school, and I'm now an IP litigation partner at a law firm in DC called Ruyak Cherian, where I primarily focus on patent litigation. But about a year and a half ago, I started taking a much closer look at the name, image, and likeness issue. I actually, as part of the ABA's annual spring antitrust meeting, drafted a paper last year that addressed this issue in the context of social media, social advertising, and influencing, which now is, essentially a full-fledged industry that needs to be considered as part of these discussions. And so that background and experience is essentially what brings me here today to discuss this issue with you all. And now, as you're aware, there's a tremendous amount of activity around this particular issue. I believe Tom touched on it earlier. He touched on the different federal bills that are being considered at the U.S. House of Representatives. He touched on states who are currently looking at this issue from a state level. And of course, the recent NCAA's formation of the working group will also look to address this issue. And now with all of the various federal and state bills that are pending, the real danger is that we could end up with a patchwork of litigation around this issue, and then the NCAA would have to essentially be playing catch up to that and trying to figure out, okay, well, how do we comply with, this specific provision in the California law versus this federal law? How does it all work together? And I think the NCAA's formation of a working group to really tackle this issue before hopefully it gets to that stage is something that makes a lot of sense, and hopefully will allow for a more comprehensive proposal and a more comprehensive system to be developed around this issue. And now I think, as a former student athlete, I think it is important to consider what the actual impact of student athletes will be under this non-game name, image, and likeness proposal, and the potential benefits of that. Gabe touched on a number of those and a number of the potential downsides, but I think another pretty important issue is just considering, daily life of these men and women who are playing sports at their colleges and universities, whether it's D1, big time D1, smaller school D1, all the way down to D3. And the one issue that kind of always pops into my mind is just the fact that, we're talking about potentially allowing kids to work during the season, but if you're in season, you're probably spending anywhere from 25 to 40 hours on your sport. Add into that, a full course load and the typical, internships and those types of job opportunities really for a student who has all of those demands on him or her already. Unfortunately just doesn't really mesh well with their demands. And so I think that's why I go back to more of a promotional type of use for students' names, images, and likenesses, and in particular, social advertising, social media, and social influencing uses of that name, image, and likeness. I think really, I consider myself kind of straddling two generations because I didn't really have Facebook in college. I think we kind of got it maybe my sophomore year, and only a couple schools had it. But having stayed in touch with a lot of folks at Georgetown, and having met a lot of those players who have come after me. It really is a thing that a lot of student athletes currently spend a lot of time doing. So they're very familiar with, how these different mediums work, the rules around those mediums, and they all know that there are a lot of people who are making money solely by posting pictures of themselves with products on Instagram, pictures of themselves with products on Facebook, and it is a real industry. The states have various regulations that determine, the types of disclosure requirements and the types of products that can be advertised on these mediums. And given the fact that, student athletes realistically just do not really have time to work during the season, this particular use of their names, images, and likenesses could provide them with a means to, earn a couple $100, earn a couple $1,000 per post, just to have some pocket money. There was an article that Amy pointed out to me recently, and in that article, the University of Oklahoma's basketball coach, Coach Kruger, he was looking into this issue a bit for himself. He wanted to see, okay, I've heard about this, but what would the impact be on my athletes? And so he went around his community to a couple local businesses of various sizes and said, this is an issue that we're all thinking about. How would you see this fitting into your business? And he was pretty shocked by the results. Most of the small business owners said that, they would welcome being able to have student athletes on numerous teams, not just a superstar, but, the second string guys and girls. He'd welcome having these individuals partner with those businesses and support those businesses and be able to use their name, images, and likenesses in advertisements for those businesses. And in my personal experience at Georgetown, I could see how, really, and I'm not necessarily talking about the superstar athletes, because that, I think, that is kind of a separate, it's just a separate environment, and I think, there would be a kind of a different experience that those men and women would have. But I think for the vast majority of NCAA students, student athletes, typically your team will go to different restaurants, your team will go to, different places to buy clothes, just different places and businesses in the community. And naturally, since, you are playing sports in college and people do want to get to know you, and so you get to know a lot of these business owners and you form real relationships with these people. And everyone knows that, the NCAA rules as they're currently written and interpreted, they're pretty clear that at the very least, if there is any sort of transaction between a business owner and a current student athlete, that could and likely will lead to issues. So the business owners always want to help, and they're always looking for ways. They say, hey, just let us know if there's anything we can do for you guys. And the answer, obviously, is that there really isn't, because under the current rules, they can't really work with the student athletes. But in my experience, I think that if there was a system under which business owners could have these student athletes come in and not just be patrons of those businesses, but also actively promote for those businesses in some capacity, I think both sides would really benefit greatly from that. And I think it could be done in a way that, A, provides these student athletes with a bit of extra money during the season and after the season that they really just can't earn by working a normal job. And then B, do so in a way that really doesn't interfere with the student athlete's ability to dedicate those 30 hours a week to their sport, dedicate those, 25 to 30 hours a week doing what they need to do in class and keeping up with all the other demands of just being a student in college. So I think that I'm very, very just encouraged by all the progress around this issue, very encouraged about the news of the NCAA working group around this issue. And I think that, really taking a close look of social advertising, social influencing, and its kind of fit in this realm of non-game name, image, and likeness use, I think is something that should definitely be considered as part of this discussion. And I'm hopeful that it will be, and that, we will get to a place where we've got kind of a comprehensive set of rules and guidelines and really protections in place to make sure that this is implemented in a way that makes sense for everyone at the table.
Great. Thank you so much to all our panelists. We'll open it up. We have probably 15 minutes for questions. Yeah, Eric?
do you see a litigation limit here where each step of the way there isn't a challenge? So you have a model where you do name, image, and likeness, and the athlete gets to have the money after they graduate. Well, why can't I have it now? And so it's just litigated again. And you do something with educational expenses, and here's the next thing that a school defines or somebody defines as an educational expense, and it's out of bounds for the rules, and it's just litigated again. So I realize, and I listen carefully to the bright line of amateurism. I'm not actually sure what that is personally, but so far I don't see in any of these rules that are being developed and thought that there just isn't the chance to litigate it again and litigate it again. So with all of this, are we going to reach some limit by which we know we're not going to court over it anymore?
Well, if I can start, I know, Gabe, you may have some things to say as well. So that's why the appeal in the Alston case is so incredibly important. We think that fundamentally that court has gotten the antitrust analysis and the application of the antitrust laws to the NCAA rules plain wrong. And we look forward to, in our briefing, put forward to a Ninth Circuit panel why the analysis is incorrect. Until we get clarity, and as Gabe mentioned, in the vast majority of the courts, we've gotten some degree of deference in the way the governance structure is allowed to pass rules like this. But nobody is presently looking at the Alston case as the outlier. They're looking at it as the norm, because there is this injunction that could be imposed and this idea of micromanaging. And until we get that resolved, plaintiffs' lawyers are going to keep chipping away so long as courts are willing to indulge that. So we hope we can get the antitrust analysis corrected. If not, then it really does become a legislative question, and whether or not there are going to be protections offered to an organization like the NCAA and others. But we don't think that's necessary given the history of court decisions that have favored the NCAA. Now, that doesn't mitigate the expense of litigating, and that is a very real issue. If we can continue and broaden the support we're getting from the court systems, then they will stop suing, or at least they will be disincentivized to sue.
Yeah, I agree, and I think generally this is an antitrust issue, not an NCAA issue. I think most large organizations, successful organizations, face the same antitrust risks, and they are sued constantly. And the question is, why wouldn't the NCAA wait until the Alston-Jenkins case are resolved to change any rules? And part of the more cynical answer is, if the NCAA waited till they weren't being sued to make any changes, they would never make any changes. And it's the same thing with the NFL, other large organizations, and it's because of the question asked by antitrust law, as I mentioned, is there a less restrictive alternative? So if you make it a slightly less restrictive alternative, someone can say, well, there's still something even more less restrictive than that, and so on and so on and so on. So I think it's just, again, a problem with antitrust law, unless, as Scott mentioned, the courts give the NCAA something they've been asking for a long time, which is not only the deference they get now, but really a ruling as a matter of law that amateurism restrictions are legal. That's not something courts have been willing to do, despite the broad language in the Board of Regents case. But certainly, whether it's a judicial exemption from antitrust law or a statutory exemption, that would eventually cut it off. But short of that, we're going to keep getting these cases for the NCAA, just like, again, most other large defendants.
Thank you all. This has been a very interesting session. I wanted to just follow up on the question that was alluded to by Eric, and that is the issue of if the NIL rule is changed to allow, in certain circumstances, the student athlete to be able to receive money on non-game related issues. what is the thinking behind limiting when the student athlete can use that money? My own view on NIL has evolved a lot over the 30 years. But I'm still not sure what the, really tying into the question of continued litigation on this, what the justification would be for not permitting a student athlete to take that money and use the money as any other student would who's working or doing anything else. So I was just wondering about that.
Well, I think that's one of the items the working group will have to tackle and analyze. I mean, interestingly, Judge Wilkin in O'Bannon had no trouble doing that. Struck down by the Ninth Circuit, given where cost of attendance decision came down. That's fascinating in and of itself, that the substitution of one cap for another cap or for delayed receipt of compensation is justifiable, to Gabe's point about what a least restrictive alternative is and how incredibly subjective that can be. So I don't know that there certainly have been any decisions made about whether that would or wouldn't be a part of any legislative proposal, but that risk is certainly a factor, I suppose, in that equation.
Yeah, I suppose from my point of view, I'm just not sure I fully understand the depth of the evils that could arise. So that would be one area that would be helpful for me to understand.
I do think part of the, just to follow up, sorry, quickly, part of the justification for the delayed payment, putting in a trust, is that it might interfere with educational goals, it might distract them, and it might create that further wedge between student athletes and the general student body. Those are certainly justifications I've heard. Whether you're persuaded by them or not is a different question, but.
Let's go, Jonathan, Nancy.
Yep. Thank you, first of all, for all of you being here and sharing your views on this topic. It's obviously a very timely and controversial one, and my question may come across as being sounding somewhat cynical, but it's not intended to be. Gabe, actually, I think it was Scott who mentioned one concern in going down this path would be the extent to which a school might try to use the availability or the preponderance of NIL opportunities to recruit students to the school. And I'm just trying to understand what the issue might be with that, because in some respects you can argue that a football coach or a basketball coach will use the ability to make NFL money or to get an NBA career to come to their school. I can create a path for you to get bigger earnings unrelated to playing per se, unrelated to anything educational. So I'm just trying to understand what would be the issue. I mean, other non-athletes can do their podcast and their social media campaigns on campus. They may go to a school because of the media programs, et cetera. So what would be the real issue, and if that became an issue, if that became a thing? It seems to be a kind of a marketplace-driven outcome in some respects.
Well, and I think that's where you know, the input and the views of the membership are going to be really important, right? Because we see that tension already existing in how recruiting takes place and what is a reasonable and an unreasonable inducement that is part of a young person's decision to attend a school. And I think this is just one more piece of that. I don't know, because certainly it's the issue of a bigger practice facility and a larger stadium and better this and better that. All of that goes into the recruiting environment already, to your point. I think there is this tension that exists perhaps about rural versus metro, national footprint versus local footprint, those kinds of things that then arguably distract from what the person should be focused on in their educational choice in the first place. But you could certainly make the point that there are already plenty of distractions and factors in what a young person deals with. I think that's going to have to be addressed.
Quickly,
Yeah.
one of our ADs who has a cross-state rival said, look, if you go forward this, the cross-state rival, every one of those players will have a new car. And that's really vividly pointed out. Then I went to another state and talked to a young AD, and the young AD said, Well, that other school already has new cars for all their players, so I've heard the gamut.
One of the things that I think is going to be a concern potentially within the membership is the level playing field with respect to competing for championships, and whether the structure has to also change to accommodate this new reality, because there already are schools that aren't as well resourced as folks that they compete against, but now you lay on top of that the chance to entice the very best players because of the inducements of NIL, and then how do schools that just don't have the same market opportunities, how do they compete, and how do you tell the athletes that you're still competing for the same championship that's already probably out of their reach? And is that what the NCAA structure wants to promote? Or do we need a fourth division, which ironically is what people suggested they would potentially go to when they didn't get autonomy, if they didn't get autonomy, and now it may be that it's required or necessary because we just can't find an equitable solution with respect to competition.
Yeah, and the reason I said it was somewhat cynical is because I think to this day there are so many other factors that lead to kids going to schools, be it practice facilities, I mean, let's face it, the Southern District of New York has already identified reasons that kids go to certain schools under the table. This simply makes it more transparent, and you can control it much better. I mean, I would argue that if we really care about academics, the Ivy League should have the best athletes, and that's not the case. So, again, I don't want to sound cynical, but, the marketplace at some level, be it in a big market, small market, things change, and at the end of the day, there's only one basketball, no matter how many players you put on the court, and so you can't get them all. So, anyway.
Let's go Nancy and then Bud.
Well, given that several of you have prefaced your comments by how long you've been dealing with this issue in your personal experience, and frankly, I think since I came on this commission, this has been a top issue, and there were even a couple days when I thought, we're really going to do something about this, the antitrust particularly. So along comes Gabe Feldman. I think this is new, thinking that we parsed it out in a way where we've separated performance, as in the game, from other accommodations to NIL. So rather than trying to figure out all the inequities that could come from all of this, which we already have inequities in conferences and the NCAA anyway, we have people who make a lot of money and people who don't make any money, and we haven't figured out a way to resolve that either by our conferences and by the college football playoff in particular. So I'm wondering, from your side, you could say the Knight Commission could just be quiet. Keep your head down. Let us lawyers figure this out. But if, in fact, we're trying to reach a place where we're sort of trying to parse this out and have a little bit of a win-win, what would you advise are the sort of policy statements? Is it a policy around equity? Because there are people making money for other people that are not getting a piece of it. Is it a policy to protect a level of amateurism that seems somewhat fleeting to us? I just wonder, as a group that's going to try to comment on this, if not today, eventually, keep commenting on it, what would you most, maybe this is a question for Gabe, but Tom has got, and Scott, everybody's commenting on this. What would a policy advocacy group, reform group like the Knight Commission have to say at this moment? Wait for the working group? I mean, that doesn't seem very interesting. I think it will be helpful, but it's not going to move things very fast or very dramatically. So I'm sorry for the complicated question, but I really want to know, what do you think our role might be in helping move this forward? Either close it down or keep it open or move to some resolution.
I was going to say, I do think the timeline of the working group, like the basketball commission, is going to be rapid, right? So, again, they haven't met yet, but the charge to them was by October of this year, come forward with your views about whether it is a system that, an NIL system that can exist within the principles and values. So between now and October, I think each and every one of you and as a group have an opportunity to provide that input to the working group that address the types of things you would like to see and also the things that maybe go to a more basic question about, as you said, equity and division of resources and the like, which is not the charge of the working group. So not necessarily input that would be received there, but certainly one that I know is on your minds. So as it relates to NIL, I think the opportunity is now to provide that input, because I don't think it will continue to fester as it has.
I would say that the body politic of our ADs is shifting on this, and a lot of it to Gabe's point, which is that you talk about 500,000 student athletes in the NCAA with probably 55,000 in our 131 schools. But when you talk about the ones that really have market value that we ought to be discussing, it's a fairly small group. Matter of fact, when the Knight Commission met last time, 16, I think we talked about 50 kids. I think it's a bigger universe than that. But I think by taking care of that universe and evolving the model, I think you take a lot of the pressure off the pay-for-play model. And so that's why, that's my own view, my personal view, is that I think if you address this on the margin, I think you do a lot on the pay-for-pay issue.
Let's go Bud and then Michael, final question.
So one of the things that was discussed prior to the establishment of the working group, the NCAA's decision to, Board of Governors' decision to establish the working group, was to just conduct an exercise and try to imagine what intercollegiate athletics look like with student athletes that can personally benefit from the sale of or profit from their name, image, and likeness. So just, and I'm not trying to do it now, but just sit down and have a conversation with 3 or 4 people and say, what does that environment look like? What are the outcomes that would come from that? We're going to have universities that are athletic departments that are going to establish a marketing group so that I can market Amadou and his name, image, and likeness business that he's running on the side. And just, I mean, that's a very useful exercise to say, if we go down this path, what is intercollegiate athletics going to look like and how will this transform that? How many student athletes? Part of the issue behind this, I think, that's pushing it is that student athletes should benefit from their talents. And I agree with that completely. We promote entrepreneurship and inventors. We promote ballet, people that participate in drama and music, and universities promote all of those things, but we restrict athletes from benefiting from their talents. But if part of the motivation here is to make sure that student athletes can benefit in some way from their talents, how many student athletes are really going to be impacted and affected by the name, image, and likeness issue?
Well, just as a brief answer to that question, I think in terms of the individual deals, if we allowed student athletes to make individual deals, that might be a relatively small number. I don't know the answer to that. It's hard to say because the market has been suppressed. But if we allow also group licensing deals for video games, trading cards, that could be a very large number. That could be a small amount to a large number of students, but if you include all of the student athletes in another video game, if it comes back out, just like in the professional leagues and the players' associations, the players don't get a lot of money from that, but it impacts all of them because they're all in the game and they all get an equal share of that. So I think in some ways it would impact all of them, at least at the Division I men's basketball and FBS football level. And I think just to quickly comment, I think in terms of policy, I think Tom and Scott touched on it, and just fairness, equity, and just broadly student welfare. I think this is a student welfare issue. And I think it's just in the interest of promoting and protecting student welfare and the fairness to the student athletes.
Yeah, just 2 points of sort of positioning, and so I agree with Bud's concerns, and as a university president, find it extremely difficult to imagine managing such a world. And so just the sheer management of such an environment would be almost beyond our capacity. Secondly, I strongly support the notion of rethinking the scholarship model itself overall to cover all of a student athlete's expenses, et cetera, et cetera. The NCAA rules are archaic in many ways relative to scholarships. Having said that, though, there's another point of information just to put on the table, and that is universities are not just places for student athletes. They're places for faculty. Faculty members, their inventions the universities own. Their copyrights the university own if the university made any investment in the development of the copyright itself, including their educational content. Their name, image, and likeness cannot be used with the name of the university for the benefit of the employee or the faculty member without the permission of the university for which it isn't granted. And so there is an environment in which all of this sits, in which there are students, there are staff, and there are faculty members, for which there are elaborate policies. Take away the name of the university from the student athlete itself. Completely different arena at that point. And so there's a notion here of there's more at this that is just than student athletes themselves. There's a range of variables and a range of complexities here that go beyond anything that are, and the reason this is so difficult and takes so much time to work through is that it's like unheard of within the culture itself. And so this is beyond the culture's capacity to imagine.
So I'd just like to just make a quick kind of point on that. So at the elite level, a lot of these student athletes, before they step foot on a college level, they've got millions of people that are following them. And this was kind of a point I touched on in my paper, but Zion Williamson, his senior year of high school, before he ever put on a Blue Devil uniform, he had 1.3 million people following him on Instagram. And that was, you know, not because of Duke, that was because he was Zion Williamson and he had this phenomenal athletic ability. And I think at the highest levels, which is, you know, the types of athletes that I think a lot of us have been focusing on today, a lot of these individuals, they're coming into college with these followings. They're not necessarily getting these followings because of their particular university. Obviously, the followings grow once they matriculate into school and once they're being broadcast to broader audiences. But I think I just want to make it clear that, you know, I think a lot of these elite individuals, they are coming into school with these followings, and they're also not employees of the university. They're students. And I think that's a point that.
Does following mean revenue for that high school student with 1 million followers? Does following mean revenue for that high school athlete?
If they are allowed to.
Not yet. Yeah.
Right. If they could.
Yeah.
$10,000.
Funny how that works.
For a couple minutes of work. It's a different environment.
Can I intervene real quick too? So when he had 1.3 before he went to Duke, now he's got how many you said? 3.3 million. Okay. So think about the platform that Duke did for him in his career, because there was talks about him signing a shoe deal last summer, not going to college, just working out. And there was rumblings that if he did that, he would have been a 15 to 20 pick in the draft, because he hasn't proven himself. All he did was show himself play against high school players. He went to Duke, had an incredible year. He's now going to get a $100 million shoe deal, and is now going to be the first pick in the draft. So to say that universities don't allow you to promote yourself, that's false. I think that place, the platform he was on, allowed him to triple what he's going to make eventually in his rookie contract. And that's just his rookie contract.
I'm going to kind of segue from the conversation, but I will say that I was a direct recipient from the O'Bannon case in terms of the NCAA money from the game. So, you know, I can't remember the check. I want to say it was around $8,000. And I was in the NFL at the time, so it didn't have the same effect on me. But I do know some of my college teammates who were in that part of transition, and what that could do is, you know, 4 months rent, an opportunity for them to get on their feet. So I don't know how it gets there, but I do know it will help. So I just wanted to make that comment on that. But my question is actually for Eric. As a former player, you know, we have a process when we retire that we can actually get a line of duty benefit. And I mean, that process is just the most, I've never been so poked and prodded in my life, but actually did end up qualifying. So I guess my question for you is, you know, with all these disability benefits that you can apply for, how hard are they to receive?
That's a good question. So there's two different types of disability benefits you can collect on. Obviously, if you have a personal policy, a permanent total disability policy, or loss of value, or critical injury, or even for endorsement protection, there's a product called temporary total disability where if you're not on the court playing, they're not paying you, so you can file a claim. So on the personal standpoint, if you look at it just from my book of business, for example, so in 2018, I think I wrote 110 sports cases, right? I have one potential claim right now. So if that's less than 1% of the time, does someone have a disability policy on a personal standpoint that's going to file a claim, that's going to collect on a claim? Okay, so that's just my book. I can't speak for other books of business, what have you. Now, on the program the NFL has, obviously I played professionally, so when I retired from playing, I filed a workman's comp claim, and I was a California resident. I played for 3 NBA teams in California. And California law was very lenient to allow you to apply for those things. And so it took, I think, 3 years, doctor's appointments, all those different things, and then, the insurance company fights with my attorney, and we go back and we come to a decision. But it's definitely a lot easier for a former NFL player to collect on a policy just because it's such a more dangerous sport. If you're a running back or a linebacker, what have you, you're going to get significant amount more injuries than a basketball player, just on the long terms, including concussions and spinal injuries and what have you. And so I went through the same process as well, too. I don't have the line of duty benefit that NFL players did, but the NBA does have, workman's comp for their players.
So it's pretty hard to cash in on that loss of value, like as a collegiate athlete, like to get that payout, is it hard?
I don't like the term hard to collect on, but a lot of things have to happen in order for it to trigger and click in. So, and with that being said, these policies are not designed to be paying out all the time.
Of course not.
I mean, you see big insurance buildings, Prudential, Lincoln. There's a reason why they can sponsor, the Eagles football stadium, what have you. It's because they do a good job of mitigating risk and doing things the right way so they're profitable. But with that being said, I pride myself on doing things the right way, underwriting policies correctly, explaining to the athlete what they're buying, how it works, where the triggers are, so that there's, expectations are managed in the front end. And as long as we don't have buyer's remorse in the back end, then I've done my job. But like I said, these are not designed to be paying out. They do pay out. I've had several claims paid out for PTD and loss of value if they're done correctly. So there you go. Thanks for bringing an insurance question in here. I was talking about this so much. Appreciate it. Thanks, man.
Just one wrap-up word. Again, we want to thank the panelists here and the panelists on the earlier sessions. The Knight Commission will release a press release later today. Our co-chairs will be available to the media after this session here in this room. The panelists are invited to join the Knight Commission for lunch. And again, thanks everyone. And Commission will reconvene in this room. You can leave your materials in this room. We'll reconvene after lunch. I don't even know.